Come here, y'all. Come here. Quickly. Come on in here, y'all. Have a seat. We are here to get into a big court update. Let's get into it.
I say Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
If you are following me on X, formerly known as Twitter, then you would have seen this update in real time. However, if you are not following me, look at the top left-hand corner of your screen. That is my QR code that will give you a direct link to my X, formerly known as Twitter page. And you can get into a plethora of other court cases and sit and divulge in the conversation. Now, as I mentioned at the beginning of this video, there has been a humongous big court update regarding Megan Pete versus Milagro Elizabeth Cooper. This is an order granting spoliation sanctions. Now, this is big. Now, before we actually get started, let me make sure that y'all see my copyright disclaimer at the very bottom scrolling below. This is fair use. I am not a paralegal. I am not an attorney, and I am not a judge. I am simply saying that, hey, I have common sense and I know how to read. And without further ado, order granting spoliation sanctions. This is big. This is big, y'all. This cause came before the court upon plaintiff Megan Pete request for sanctions against defendant Milagro Elizabeth Cooper for spoliation of evidence. The undersigned conducted an evidentiary hearing after hearing argument from counsel, testimony from plaintiff's expert witness, and having reviewed the record and being otherwise fully advised, it is hereby ordered and adjudged that plaintiff's request for sanctions for spoliation of evidence is granted, y'all. This is big. Plaintiff shall be granted an adverse inference jury instruction at trial and monetary sanctions. That's big, y'all. Let's get into the factual background. This cause focused on allegations brought by Pete, a hip-hop artist known professionally as Megan Thee Stallion, against Cooper, an online personality who goes by Milagro Grams or Mobsboro. See the second amended complaint. As we all know, we've all seen it already. Okay, so let's continue. Cooper is accused of engaging in coordinated social harassment campaign using video, audio, and written social media posts to cause reputational and emotional distress to Pete. The allegations in the SAC arise from the 2022 criminal trial and conviction of Daystar Peterson, popularly known as Tory Lanez, a Canadian rapper and singer who was found guilty of assaulting plaintiff with a firearm. The criminal trial was widely publicized and had a large public following on social media. Pete SAC alleges defamation per se, count 1, promotion of an altered sexual depiction in violation of Florida statute 836.13, which is count 2, intentional infliction of emotional distress, which is count 3, and then lastly, cyber stalking in violation of Florida statute 784.0845, which is count 4. According to Pete, defendant operates multiple social media accounts across several platforms, including Instagram, TikTok, X.com, and YouTube, and has over 100,000 followers on these social media platforms. Pete contends defendant has sole control over these accounts and at Daystar in his affiliates' direction uses them to harass and defame Pete by disseminating false narratives and conspiracy theories about her. The alleged falsities include claims that Pete lied under oath during the criminal trial, suffers from alcoholism, and is mentally R-word, and needs a guardian. These alleged falsehoods and harassments have purportedly taken a severe toll on Pete's mental health. Pete asserts defendant made these statements with actual malice, as evidence disproving them was widely available at the time the statements were published. Okay, so Pete, as y'all can see here, she has laid out her claim. Now, let's get into Daystar Peterson's criminal trial. As noted, many of Cooper's alleged defamatory statements stem from the underlying 2022 criminal trial and conviction of Daystar Peterson. On July the 12th of 2020, Los Angeles police conducted a traffic stop involving Daystar and Pete after responding to reports of gunfire in the area. Officers discovered a recently discharged firearm during the stop and noticed Pete had injuries to her feet. These injuries were later confirmed to be gunshot wounds. Plaintiff was transported to the hospital while Daystar was arrested for possession of a concealed weapon. Pete later identified Daystar as the shooter, leading to his subsequent indictment on charges for felony assault with a firearm, illegal possession of a firearm, and negligent discharge of a firearm. Pete testified during Daystar's trial, recounting the night of the shooting and the impact the shooting had on her. Specifically, Pete testified that she exited Daystar's car and was walking away with her back facing Daystar. At this point, Daystar said, "Dance B," and fired multiple shots at her, injuring plaintiff's feet. Daystar was eventually convicted on all charges and sentenced to a 10-year prison term. Defendant social media harassment. According to Pete, defendant attended Daystar criminal trial and launched a smear and harassment campaign against Pete on social media at the behest of Daystar and his affiliates. Plaintiff alleges Cooper utilized bot accounts to flood plaintiff and her supporters with hateful, derogatory, and malicious statements. Defendant has also called for violence against plaintiff. Plaintiff alleges the harassment is in retaliation for testifying against Daystar during the criminal trial. Plaintiff also alleges that Cooper promoted a deep fake pornographic video depicting an artificially created version of plaintiff engaging in sexually explicit acts. Specifically, defendant on her at mobsworldx.com account liked a post featuring the deep fake video, which archived the post into her public likes page. Defendant then directed her social media followers, as well as anyone who saw defendant's posts, to browse her then public likes page containing the video. Plaintiff alleges that this action was done to amplify the video's reach. Defendant later stated on a live stream video published to her station head's account, "If y'all want to be mad at something, this is what I'll give you. Be mad that I drew attention to it."
Ooh, that was juicy.
Ostensibly referring to her conduct in directing her followers to access the video. Okay, so let's get into defendant's relationship with Sunstar Peterson. As it relates to the instant spoliation proceeding, plaintiff alleges that Cooper is a paid surrogate or mouthpiece for Daystar and his father, Sunstar Peterson, and conspired with them to execute this smear campaign to maliciously injure plaintiff's reputation and inflict severe emotional distress upon her in retaliation for her testimony during the criminal trial. Daystar himself is unable to speak or post directly regarding Pete due to restrictions in the underlying criminal action. Pete alleges that defendant has a close relationship with both Daystar and Sunstar Peterson, as evidenced through defendant's social media postings. Thus, communications between and relating to defendant, Daystar, and Sunstar are material to plaintiff's claims and are the focal point of these spoliation proceedings. Okay, procedural background. On the same day the lawsuit was commenced, On October the 29th of 2024, defendant was informed in a letter sent by email from plaintiff's counsel of her duty to preserve documents and information related to the case as detailed in the preservation letter. See notice of claims in preservation of documents and information, which I do believe that that's below this document. There is 40 pages, just to give y'all a brief, you know, stance on where we're at. We're on page 5, as y'all can see on the top right. Y'all see page 5 of 40. All right. Let me change my mic settings. Hold on, because I'm doing all, y'all can hear a lot of that. Okay, there we go. Let me see. That's a little better. All right. Let me turn my gain down. All right, there we go, baby. All right. On July 11, 2025, plaintiff first informed the court of potential spoliation and a notice of issues for discovery hearing. There, plaintiff raised concerns regarding spoliation of electronically stored information from defendant's devices and social media platforms. Plaintiff requested immediate provision of defendant's login credentials to a previously agreed upon third-party forensic vendor, FTI Consulting, for collection from defendant's Discord, iMessage, WhatsApp, and Instagram accounts. Plaintiff also requested an adverse inference regarding the uncollected and spoliated communications from defendant's device. At the discovery hearings held several days later, plaintiff's counsel explained that the forensics information of defendant's cell phone had shown that defendant deleted text messages from her phone during specific times leading up to the filing of the complaint. Plaintiff counsels noted specific deletions that corresponded to statements defendant made about plaintiff on October the 5th and the 6th of 2022, July the 29th and the 30th of 2024, and then August the 10th and the 12th of 2024. Plaintiff also explained that the initial forensic information revealed that defendant had completely deleted WhatsApp and thus any WhatsApp messages contained on the app off her phone during the litigation. The undersigned ordered defendant to provide her phone and login credentials for WhatsApp and other apps to the neutral third-party forensics vendor, FTI, for analysis prior to defendant's then notice deposition, which was on July the 21st of 2025. The undersigned further deferred on ruling on the issue of spoliation until after defendant's deposition on July the 21st of 2025, so that plaintiff could seek answers during the deposition regarding the deleted evidence. Plaintiff was permitted to renew her request for spoliation sanctions after defendant's deposition. This was also memorialized in the court's order following the discovery hearing. If after defendant's deposition, plaintiff seeks to proceed on the issue of spoliation, plaintiff must promptly contact the undersigned to request an evidentiary hearing. During the hearing, the undersigned also note that this case had fast approaching deadlines and that it was incumbent, however you say that word, child, upon all parties to proceed promptly with discovery. On Tuesday, July the 29th of 2025, plaintiff emailed the court renewing her request for a hearing on spoliation of evidence. On August the 4th of 2025, after giving the parties time to confer on availability, the court set an evidentiary hearing for spoliation proceedings for August the 7th of 2025. So let's get into the evidentiary hearing, which I've already covered, but let's look. The parties appeared for an evidentiary hearing on spoliation on August the 7th of this year. Plaintiff produced an expert witness from FTI Consulting. This is Matthias Livachoff, and he proffered testimony from defendant's July the 21st of 2025 deposition. Defendant announced that their expert was unavailable to testify in person for the hearing, and defendant herself was unable to attend due to a canceled flight, and it's discussed more below. Direct examination. Mr. Livachoff testified that he works for FTI and was involved in the creation of FTI's forensic analyst report of defendant's phone. The report itself provided findings regarding deleting text messages and WhatsApp messages from defendant's phone. Mr. Livachoff holds a baccalaureate. Sorry, y'all. That word is baccalaureate of computer science and has been working in the digital forensics field for 19 years, focusing on digital forensics, e discovery, and global investigations. He explained that his colleague performed the forensic image of defendant's phone using an industry standard analyst tool called Celebrate. From there, FTI was asked with identifying any deletions and usage of the WhatsApp and iMessage apps on defendant's phone. Mr. Liverchoff confirmed that FTI worked with two images on defendant's phone. An initial image taken from the phone, of the phone in April of 2025, and a backup hard drive of the phone later provided by defendant in July of 2025. FTI was able to determine deletions of text messages from defendant's phone based on missing row IDs in the phone's database. Mr. Liverchoff explained that when a text message is sent or received, a row ID number is automatically created within the phone's database corresponding to the message. The row ID numbers are created in sequential format based on when a message is sent or received. Furthermore, the row ID number is permanently assigned to the corresponding message at the time the message was received or sent. And if a message is deleted, its corresponding row ID is also deleted from the database. The phone database also notes that the time and the date of the row ID was created, which corresponds to the time and date the message was sent or received. Therefore, it is possible to identify deleted text messages based on sequential gaps in the row ID numbers. Mr. Liverchoff then displayed a demonstrative Excel sheet depicting FTI's analysts of the row ID and text message gaps found from the first imaging of defendant's phone done in April of 2025. The Excel sheet depicts row ID gaps from defendant's phone over the course of 6 years, with the most recent message showing as April the 9th of 2025. The Excel sheet depicts the row ID number immediately preceding a gap, the row ID after the gap, and the number of missing row IDs or messages within the gap. The Excel sheet also depicts the beginning and ending time step corresponding to the row's ID endpoints and the time elapsed within the gaps. An example of the Excel sheet data fields is below. Exhibits Q and R were marked for identification. Exhibit Q was identified as a message extraction from defendant's phone depicting a text exchange between defendant and Sunstar on December the 22nd of 2022 at 2:58 a.m. Specifically, Exhibit Q shows Sunstar asking defendant to call him. Exhibit R depicted three messages sent from Daystar to defendant on December the 22nd of 2022, starting at 5:33 a.m. Exhibit R depicts Daystar reaching out to defendant and asking her to contact him. Mr. Lipchoff then directed the court to corresponding sections of the Excel sheet analyst, where it showed that 66 row IDs or text messages were missing immediately after the Exhibit Q message from Sunstar on December the 22nd of 2022 at 2:58 a.m. and before the messages received from Daystar in Exhibit R on December the 22nd of 2022 at 5:33 a.m. Moreover, there are 276 row IDs missing after the messages received from Daystar in Exhibit R. These 276 missing row IDs represent 276 missing text messages spanning 13.24 hours from December the 22nd of 2022 at 5:33 a.m. The time of Daystar's last message to defendant, the December the 22nd of 2022 at 6:47 p.m. These gaps from the Excel analyst are provided below. And y'all can see they put in the actual Excel exhibit. Plaintiff and Mr. Liverchoff continue to exercise with Exhibit S, which depicted a four-message text conversation between Sunstar and defendant on October the 30th of 2024, wherein Sunstar asked defendant to call him. The first message was sent by Sunstar to defendant at 3:27 p.m. on October the 30th of 2024. Thereafter, FTI identified a gap of 68 missing messages following the first text from 3:27 p.m. to 7:04 p.m. Exhibit S also contains three more messages between Sunstar and defendant on October the 30th of 2024. At 11:15 p.m., Sunstar again asked defendant to call him. At 11:24 p.m., Defendant let Sunstar know she is on air but is about to get off. And the final reply from Sunstar at 11:25 p.m. indicates that they will talk soon. FTI identified a gap of 258 missing text messages spanning 14.10 hours following Sunstar's last message at 11:25 p.m. On October the 30th of 2024 to October the 31st of 2024 at 1:30 p.m., Exhibit T also marked for identification. Exhibit T depicts another text message received by defendant from Sunstar on November the 6th of 2024 at 7:52 p.m. asking defendant to call him. Mr. Liverchoff testified there were 89 missing row IDs in text messages from defendant's phone following this text, ranging from November the 6th of 2024 at 9:30 p.m. to November the 7th of 2024 at 12:52 a.m. Mr. Liverchoff also identified row ID gaps and deletions of 576 and 246 messages preceding this text, spanning from November the 5th of 2024 to November the 6th of 2024. Plaintiff further noted that these deletions, including those in Exhibit S, happened after this lawsuit was filed and was considered an active litigation period. Then it says, see the preservation letter, which again, I do believe is at the bottom of this court document, but we're going to continue. FTI, it says, ultimately, FTI was able to identify 2,337 missing row IDs in text messages in the time between Exhibit S and Exhibit T, spanning October the 30th of 2024, the day after the lawsuit was filed, to November the 6th of 2024. Exhibit J was thereafter marked for identification. Exhibit J is a screenshot of defendant's phone recently deleted folder depicting a deleted message thread with Sunstar containing 4 messages. The screenshot indicates that the thread will be automatically and fully deleted from defendant's phone in 30 days. Exhibit AA was marked for identification, depicting the same screenshot of defendant's recently deleted folder, but with added metadata fields. Liverchoff testified that the metadata shows that the screenshot of defendant's recently deleted folder was created on or around November the 14th of 2024. He also later confirmed his creation date based on his own search of defendant's phone. As part of FTI's analysis, Mr. Liverchoff also reviewed WhatsApp usage from defendant's phone. Mr. Liverchoff testified that WhatsApp was not downloaded on defendant's phone during FTI's first image collection done on April the 5th of, well, not April the 5th, but April of 2025. However, FTI was able to determine, based on Wi-Fi traffic generated by the app, that WhatsApp had been used on several dates preceding the collection. Indeed, a review of Exhibit M shows that WhatsApp was active on defendant's phone on 7 dates spanning from July the 4th of 2023 to March the 18th of 2025. Mr. Liverchoff reiterated that though FTI was able to see WhatsApp activity on the device, the app itself was not downloaded on defendant's device when it was turned over to FTI in April of 2025. Therefore, it appears that WhatsApp was uninstalled before defendant's device was turned over to FTI, and Mr. Liverchoff testified that any messages held on the WhatsApp are lost unless there is a backup of those chats. Exhibits X, Q, R, S, T, J, M, F, and E were thereafter admitted into evidence, and the witness was tendered for cross-examination. Exhibit AA was later admitted with restrictions during redirect examination, as discussed below. So let's get into the cross-examination. During cross-examination, Mr. Liverchoff confirmed that the missing row IDs represented missing text messages from defendant's phone. Mr. Liverchoff admitted he could not determine who sent or received a missing text message based only on the row ID gaps, but he could confirm the phone number of the individual who had sent the messages right before and directly after the gaps. He further testified that the only way to recover the missing text messages would be from a backup containing the messages. Mr. Liverchoff confirmed that the row ID analysis done during direct examination was based on the first imaging of defendant's phone captured in April of 2025. Mr. Liverchoff testified that it is possible that the row IDs depicted in FTI's analysis could have been created on multiple phones. Defendant purchased a new phone and transferred the data from her older device. However, based on his experience, when data is transferred from one phone to another, the entire database is transferred with it. If defendant were transferring her data to a new phone, she would not be able to pick and choose specific text messages to carry over to the new phone. Mr. Liverchoff testified to the number of missing messages from the first analyst of defendant's phone per year from 2019 to present. And as y'all can see there, this is showing you missing messages. Y'all see that? Okay, so let's get into moving forward. All right. So he confirmed that each missing row ID represents a missing text messages, that the missing text messages could be from group messages, and that he is unable to tell when the messages themselves went missing or were deleted. Rather, FTI can locate the time span of deleted messages based on the row IDs before and after the gap. Mr. Liverchoff mentioned that errors could possibly cause row IDs to go missing, but he has not encountered that in his experience. Mr. Liverchoff confirmed that Exhibit AA's metadata fields were created from the first imaging of defendant's phone, and that defendant did not modify the metadata of the screenshot on July 11th of 2025. He further confirmed that he had recovered the screenshot from defendant's recently deleted folder depicted in Exhibit J, and that it was not modified. When asked about the WhatsApp activity found on defendant's device, Mr. Liverchoff testified that the dates of activity did not tell him whether messages were sent or received by WhatsApp on those dates. Rather, it shows WhatsApp was active over Wi-Fi on those days. The parties then discussed the second imaging of defendant's phone based on a backup hard drive that was turned over to FTI in July of 2025. Mr. Liverchoff testified that there were messages found on the backup hard drive that were missing from the first imaging of defendant's device in April of 2025. FTI found that there was a 13,000 message difference between the first imaging in April and the second imaging of the backup in July. However, this calculation also included new messages sent and received after the first April 2025 imaging, including messages sent up to July the 17th of 2025. Mr. Liverchoff confirmed FTI only captured whether WhatsApp was deleted from the device. WhatsApp had been deleted in the original April 2025 imaging, but had been re-downloaded in the subsequent July 2025 backup, now containing 6 messages, and then redirect examination. Mr. Liverchoff presented 2 Excel sheets during redirect examination depicting FTI's analysis of missing row ID gaps from defendant's phone. The first Excel sheet, also shown during direct examination, depicted FTI's analysis of the first image of defendant's phone in April of 2025. The second Excel sheet depicted FTI's continuing analysis of the second image from the backup hard drive provided in July of 2025. Mr. Liverchoff, using row ID gap dates from previous exhibits, compared the 2 Excel sheets to see if any messages missing in the April file were recovered in the July file. Mr. Liverchoff examined the December 22nd, 2022 messages in Exhibit R and found that the row ID gap 66 and 276 were identical in both April and July files. The same exercise was repeated with one of the date ranges from Exhibit S, October the 30th of 2024, from 3:27 p.m. to 5:04 p.m., showing matching row ID gaps in both the April and July files. Mr. Liverchoff then acknowledged that while he cannot pinpoint exactly when certain row IDs and text messages were deleted, logically, it would have to be after the message was received or sent. For example, if row IDs and messages were missing on April the 30th of 2024 between 12:01 p.m. and 12:03 p.m., the messages would have been deleted at the very least. after October the 30th of 2024 at 12:03 p.m., the time the last available message was received or sent. Recross examination. During recross examination, defendant pointed out that in one of the examples used on redirect, there were 190 messages recovered in the July file. Thus, the April file and July file did not match completely for those time periods. And then deposition testimony. Plaintiff presented excerpt video clips from defendant's deposition on July the 21st of 2025. Redirect examination. Mr. Liverchoff was briefly redirected on Exhibit AA. Mr. Liverchoff was unable to testify to the last modified metadata field on Exhibit AA as he did not access the database that produced the metadata for the exhibit. However, he was able to confirm the creation date of the screenshot in Exhibit AA and Exhibit J as November the 14th of 2024, based on his personal search of defendant's device. Therefore, the court accepted Exhibit AA into evidence to the extent that Mr. Liverchoff confirmed the creation date, but disregarded the last modified metadata field. Absence of defense expert in defendant at hearing. Lastly, the court notes that neither defendant nor her expert testified at the evidentiary hearing. While defense counsel stated that defendant's expert could have appeared via Zoom, no explicit request was made to the court prior to the hearing. Moreover, as stated during the hearing, it is unclear what more defendant's expert would be able to provide, as it is uncontested that messages had been deleted from defendant's phone and that some were deleted after litigation commenced and defendant received the preservation letter. Defendant was also unavailable due to a last-minute flight cancellation that prevented her from appearing. However, defendant was deposed 2 weeks prior to the hearing, where she testified about the deletions under oath. Further, defendant's counsel was able to make factual pro-offers based on the deposition testimony during the hearing. And then here goes the legal standard. At its core, spoliation is the destruction of or significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. Federal law governs the imposition of sanctions for failure to preserve evidence in a diversity suit. And this is just quotes from different court cases. And that is legal standard. So if you would like to read this on your own, as always, I will have this court document linked in the description box below. Or if you're on my Twitter page, well, X page, formerly known as Twitter, you've seen it first. Or if you would like to follow me, top left-hand corner. But we're just going to scroll past this part. And we're going to get into... I just want to scroll and see. What was the conclusion? That's what I want to get to. Bad faith. Y'all see that? Ooh. Defendant engaged in an affirmative act causing evidence to be lost. Okay, so here goes sanctions. Adverse inference. Okay, so let's look at sanctions. As discussed above, there are two types of sanctions available under Rule 37E. First, under Rules 37E1, if the adverse party has suffered prejudice from the spoliation of evidence, the court may order whatever sanctions are necessary to cure the prejudice. Second, under Rule 37E2, if the court finds the party acted with the intent to deprive another party of the information used in the litigation, the court may order more severe sanctions, including in instruction to the jury that it may or must presume the information was unfavorable to the party. Here, plaintiff seeks an adverse inference. Okay, so let's get into this. Adverse inference. Here, for the reasons stated above, the court finds that an adverse inference is appropriate to cure the spoliation of messages and data from defendant's phone. There are different types of adverse inference, each within increasing levels of harshness based on the nature of the spoliation. The harshest type of inference instructs the jury that certain facts are deemed admitted and must be accepted as true. A second type results in the imposition of a mandatory but rebuttable presumption. The least harsh adverse inference allows the jury to presume that the lost evidence is relevant and favorable to the innocent party. That latter type of adverse inference also allows the jury to consider the spoliation party's rebuttal inference and gives the choice of whether to draw an adverse inference. I'm sorry. Here, plaintiff requests an unrebuttable adverse inference as follows. Okay, so girl, we got some tea, girl. We got some tea, y'all. We got some tea. It says a party to a lawsuit, such as the defendant, has a legal duty to retain and preserve paper and electronic communications and other documents that concern the case. This includes, amongst other things, all electronically stored information in one's possession, custody, or control, such as emails, text messages, and other communication stored on applications on one's phone, computer, or in the cloud. The day before plaintiff filed this lawsuit, her attorneys formally noticed defendant that plaintiff was going to file the case and that she had these retention and preservation duties. Despite this written notice and these underlying legal duties, defendant deleted several thousand text messages, emails, and chats from her phone and her WhatsApp and Discord accounts. In reaching your verdict, you should assume and infer that the documents that defendant deleted would have shown that her statements about plaintiff that are at issue in this case were false and that defendant either knew them to be false when she made them or had serious doubts about whether they were true when she made them. As explained in detail above, the undersigned notes are severely and seriousness of the spoliation that has taken place here and defendant's lack of cognate explanation for the same. However, plaintiff's proposed adverse inference requires the court to assume facts that have not been proffered by the evidence, namely that the spoliated messages would have explicitly shown defendant's statements were false and defendant knew or should have known them to be false. Okay, so we're just going to scroll. Okay, so let's look at this. Defendant notice of hearing. Lastly, the undersigned must address the objections defendant raised before and during the hearing regarding notice. As stated before, the parties had been aware of the potential of spoliation proceedings since at least plaintiff's July 11, 2025 notice of discovery issues and the July 14, 2025 discovery hearing. It says Tuesday, July the 29th of 2025, plaintiff emailed the court renewing her request for spoliation sanctions, citing new discovery pointing to blatant and rampant spoliation. Plaintiff's counsel indicated that they had conferred with defendant's counsel that morning on the issue and was planning on continuing conferral efforts on the morning of July the 31st of 2025. Defendant's counsel emailed the court that same night, July the 29th, informing the undersigned that she would not be available for a hearing until at least August the 6th of 2025. On Thursday, July the 31st of 2025, plaintiff emailed the court detailing new evidence of purported spoliation and again renewing the request for spoliation sanctions. This included new information found on FTI analysts of defendant's backup drive and defendant's testimony from her deposition. Plaintiff's counsel also stated that no meaningful conferral had yet occurred as both of defendant's attorneys had been unavailable and did not understand the rush in meeting and conferring. Plaintiff also attached an email thread to the July 31st correspondence detailing messages between the parties NFTI extending back to May the 5th of 2025. From this attached thread, it appears that FTI updated the parties on July the 25th of 2025 of their findings from the review of the backup drive. Thereafter, on July the 28th of 2025, plaintiff's counsel reached out to defendant's counsel indicating the intent to renew the spoliation request and asking to meet and confer multiple times. Defendant's counsels reiterated, y'all listening? They reiterated that they were unavailable and did not see the need for an expedited hearing on the matter. On Friday, August the 1st of 2025, the court informed the parties by email that it would hear the spoliation issues during an in-person hearing on August the 6th or August the 7th and requested counsel's preference based upon their availability. On Monday, August the 4th of 2025, the court informed the parties that it had set an in-person evidentiary hearing for August the 7th at 9:30 a.m. on August the 5th of 2025. The court apprised the parties that it had set aside 2 hours for the hearing. On August the 6th of 2025, the day before the hearing, defense counsel forwarded the court an email thread between the parties detailing a meet and confer call that purportedly took place on either the 4th of August or the 5th of August, and requesting the evidentiary hearing be moved based on a purported stipulated extension of fact discovery. Plaintiff objected. The court reminded the parties that plaintiff had renewed its request for an evidentiary hearing more than a week prior on July the 29th, and that defense counsel had previously represented to the court in her July the 29th email that she would be available for an evidentiary hearing after August the 6th. Therefore, considering impeding case deadlines, the hearing would proceed as set. With respect to defendant's expert witness, defense counsel later at 5:12 p.m. on August the 6th forwarded an email thread indicating that defendant's expert would be unavailable to testify in person at the hearing next day. Notably, defendant did not proffer, I'm sorry, I've been saying the name wrong, their expert's opinion on the missing text messages at the evidentiary hearing and have yet to make a proffer. Moreover, and then it says let me see, the fact that the messages were missing was fully explored at defendant's July deposition, and that the message are in fact missing and is not in dispute. Pause your screen if you want to read this part. I'm going to go on to the conclusion. So we're at the end. Conclusion. For the foregoing reasons, plaintiff's request for spoliation sanctions is granted as follows. Plaintiff is entitled to submit the following jury instruction at trial, pending any alteration or amendment the district court judge deems necessary. A party to a lawsuit, such as the defendant, has a legal duty to retain and preserve paper and electronic communications and other documents that concern the case. This includes, amongst other things, all electronically stored information in one's possession, custody, or control, such as emails, text messages, and other communications stored on applications on one's phone, computer, or in the cloud. The day before plaintiff filed this lawsuit, her attorneys formally notified defendant that plaintiff was going to file this case and that she had these retention and preservation duties. Despite this written notice and these underlying legal duties, defendant deleted thousands of text messages and removed the WhatsApp from her phone that potentially contained messages and chats. In reaching your verdict, you should assume and infer that defendants intended to deprive plaintiff of the evidence in the deleted messages, that at least some of the deleted messages related to the claims in this case and were about plaintiff, and that the deleted messages were unfavorable to defendant. The parties shall meet and confer within 5 days of entry of this order as to a reasonable amount of fees and costs that plaintiff incurred by having to bring this spoliation issue to the court's attention, including costs incurred as a result of the evidentiary hearing. If the parties cannot agree, then within 10 days of entry of this order, plaintiff shall bring the matter to the undersigned's attention by contacting Chambers to provide the undersigned with the amount requested, along with the time entries establishing the amount. The defendant shall then have 5 days thereafter to respond. And that is the end of this court document. What a show, y'all. What a show. Again, like, share, and subscribe. As I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I'm getting out of here, y'all. Y'all have a good one.